Welcome to Making the Case. I'm Yodit. The U.S. Supreme Court has unanimously ruled that people serving extreme sentences for possession of small amounts of crack cocaine under the 1986 law that created a 100-to-1 weight disparity between crack cocaine and powder cocaine were not entitled to be resentenced. Here to give us a breakdown of what this landmark decision really means is former federal prosecutor and defense attorney Michael Moore and Professor Carl Hart, a neuroscientist at Columbia University and author of Drug Use for Grown-Ups, Chasing Liberty in the Land of Fear. Thank you both for being here. All right, there you guys go. All right, Carl, to you first. The 100-to-1 crack versus powder cocaine sentencing disparity was established under the 1986 Federal Anti-Drug Abuse Act during the height of the war on drugs. So our viewers understand what the disparity means. Someone convicted of possessing 5 grams of crack cocaine faced the same mandatory minimum of 5 years in prison as someone possessing 500 grams of powder cocaine. Talk to us about what motivated the passage of the law and its discriminatory effects on Black and low-income communities.
Yeah, the main sort of motivator of this law is the misunderstanding that crack cocaine is somehow different from powder cocaine, when in fact they're the exact same drug. The only difference is that the route of administration that one uses to smoke or take cocaine is different. When you have crack cocaine, you smoke it, whereas with powder cocaine, you can snort it or inject it intravenously. But we were made to believe that crack was a completely different drug. But what we've seen in the laboratories, like my own and other people's laboratories, is that the drugs produce exactly the same effects. But in the popular culture, as well as in law, as well as in a number of areas in our sort of culture, people seem to think that crack is different. So much so different that we should treat it differently, or treat violations of crack cocaine differently than violations of powder cocaine. And of course, it's not warranted. It's not warranted on a scientific basis. It just doesn't make any sense.
So, of course, these are 2 forms of the same drug, is what you're saying. So there's no differences in the way that they affect you neurologically?
No, there's no difference. Powder cocaine has an attached compound called the hydrochloride salt, whereas with crack cocaine, that hydrochloride salt is not there, but that hydrochloride salt doesn't add anything to the pharmacological effects of cocaine. They are the same drug. It's just that one can be smoked and the other cannot. That's it. It's like saying, for example, we're going to punish people more harshly if they're smoking marijuana than those who are taking marijuana by mouth. It doesn't make any sense. And the thing that is really abhorrent is that more than 80% of the people who were convicted under those laws are Black. In the 90s, that number was more than 90% of the people convicted under those laws were Black. And so people say that the crack powder laws are racist. Let's just be clear. Laws are not racist. It's the people who are enforcing those laws and the folks who allow this sort of thing to continue. Those folks are the racists. The laws are just laws. It's how we enforce these laws. That becomes racist.
Michael, the 100-to-1 weight disparity was modified to 18-to-1 by the Fair Sentencing Act of 2010, which was signed into law by President Obama. You were a federal prosecutor. Talk to me about your experience having to charge and prosecute drug cases under that legislation.
You know, the original drug laws did have a disparate impact, and there's really no arguing about that or even a question about it. And they were simply a reaction at the time to what we saw as sort of massive overdoses, deaths. We saw people preying on other folks by selling drugs, and it was a time that it clearly was an overreaction and had a great detriment and disparate impact. When the law was changed, then you still had, even though there was a bipartisan support to do that, you still had a disparate treatment, and that being, like you say, 18-to-1. And so the push was to try to treat people in a different way. So during the time that we were working with the Department of Justice, there was an effort to look at cases, to prosecute those cases that merited a federal intervention or a federal conviction, and not to chase what I would call sort of street level crimes. That was not enough. And I think you saw, certainly during Obama's terms, and I respected this, an effort to move forward with a clemency program. And that was a way for judges for the Department of Justice to move beyond what the judges may have done in sentencing. There are a lot of judges who were disgusted, frankly, with having to be confined to mandatory minimums, to a guideline range they thought was unfair and inappropriate. You saw actually the sentencing guideline rules changed to where the guidelines were advisory and there was no mandatory imposition. There had to be reasons to go above or below the guideline range. But you saw different aspects of the government trying to deal with what was a known problem in disparate treatment. So the clemency program was there. It was a way for the department to look at people who've been sentenced under ridiculously harsh drug laws and to come out and say, look, somebody who had X amount of cocaine and has been a nonviolent offender and has had a good behavior while they've been in jail, then we need to make sure that they get out and not spend the rest of their life behind bars. So there were efforts put in place to correct the problem. The Supreme Court decision recently just came out, sort of was a little bit of a back step, but at the same time, you still have ways that both the legislature could move around it and the prosecutors, if they're willing to, can look at the charges as well.
Well, Michael, I was about to ask you, Supreme Court decisions can be a bit confusing for some, especially as it relates to our day-to-day life. So can you explain yesterday's court decision?
The decision dealt with a gentleman, Mr. Terry, who was convicted under a certain part of the drug statute that did not require the judges to have mandatory minimums. And so what the Supreme Court did is he tried to move to have his sentence reduced. The Supreme Court said, look, if the judge had discretion, this particular section of the statute that Mr. Terry was convicted under would not apply or would not be subject to a reduction in sentence. And so we're not going to apply this new law to him. So he was, in effect, not eligible as he was not sentenced under a mandatory minimum prison sentence. So again, there is a way to move around this. There's a way to maneuver. If you're a prosecutor, the judges have a great deal of discretion, even now. But again, it will take sort of a unity in the government, and that being both between the executive branch, that being the prosecutors and the people at the Department of Justice, the legislative branch, as we look to actually correct certain laws in how they treat people, and then the judicial branch as well on how they end up applying those laws.
Carl, you believe that all drugs should be legalized. Tell me more about the connection between the criminalization of certain drugs and racism.
Well, we have to understand that the way that our laws are being enforced are in a racist sort of way. When I say racist, I simply mean that a disproportionate number of people from a specific race are being subjected to those drug laws, whereas others are not. As the attorney was saying, that we have this disparate treatment. It's not disparate treatment. It's racist treatment because it's not other racist group. It's a singling out of a racial group. And so it's important for us to understand that these laws are being selectively enforced in certain communities and not other communities. That's called racism. That's so we have to be really clear about this. And that's the sort of genesis of our drug laws. Our drug laws were not passed because of a concern about pharmacology. Our drug laws were passed because of racism. And this goes back from the first federal drug laws in 1914. We passed laws restricting cocaine and opioid products, not because of pharmacology, but because of exaggerations about Black people, exaggerations about Chinese people. That's why these laws were passed. And so when we think about what the country stands for, this sort of life, liberty, and the pursuit of happiness, as long as you're not disrupting other people's ability to do the same, why are you arresting people for what they choose to put in their bodies? It doesn't make any sense. Certainly not any sense when you think about the promise of the country.
Michael, last question. There's a bill before the Senate that would do away with the crack versus powder cocaine disparity altogether. Given what we've seen with voting rights legislation, do you think that this has a chance of being passed?
You know, right now with the Senate the way it is, I don't know how much you get through there, but at the same time, you did see bipartisan efforts to equalize in some way, or at least cut down on the disproportionality of how crack and powder cocaine were handled. But my friend Carl, though I think he may be painting with a little bit broad brush when he talks about the enforcement of all these drug laws are racist. I'll tell you, I've prosecuted drug kingpins, I've prosecuted drug dealers, I've prosecuted conspiracies as they go, and what I've seen are people who take advantage of members of their own community, and they see this as some kind of economic boon, and they use it as an enterprise to harm the most vulnerable people without regard for what it does for families that live in their town, without regard for what it does for the children, without regard for what it does for people's employment ability, any of that. They use it as a way to enrich themselves, even though they may happen to be the same race as the user or the person who ultimately gets convicted for having possessing some kind of drug. There are things that we need to fix. There are things that we need to look at as a nation to not have disparate treatment. But I can tell you, when a prosecutor has a drug case brought to him and you're looking at a kingpin selling to, you know, hundreds of people out there, it doesn't matter to me if they were black or white. Or I look at the fact that they are victimizing these people in the community. So we may see it a little differently, but I think we can agree that, in fact, there needs to be correction legislatively, and I hope they'll do that with the new bill.
Carl, I was going to actually end this segment, but I could see that you have something to say, so I'm going to go ahead and let you respond to what Michael said.
Exactly. Well, Michael is just putting out anecdotal information. There are very few kingpins who are actually in prison for selling drugs. Kingpins typically don't go to prison. And then when you look at the numbers in terms of the racial breakdown of who's behind jail for drugs, it is overwhelmingly black. So when you look at the evidence, not some anecdotal sort of information that you prosecuted some person who took advantage of some people, when you look at these overwhelming numbers of black and brown bodies behind bars for selling drugs, when we know the majority of drug sellers are white.
Okay.
We may finish this on another day, but I've never seen Carl in the courtroom with me when we were locking people up. But we'll finish it on another day.
We're going to leave it right there. Definitely going to bring you guys back to debate this even more at a later time. Former federal prosecutor Michael Moore and neuroscientist Carl Hart, thank you both.
Thank you, Dan. Good to be with you.